The decision by Supreme Court Justice Njoki Ndung'u to suspend the retirement of two of her colleagues from the bench perhaps ratchets up the drama that has continued to follow the topmost court. Justice Njoki Ndung'u issued these temporary orders to save their jobs pending the Supreme Court hearing of an appeal of the High Court's decision to send them home and affirmed yesterday by the Court of Appeal. But there is a legal question of who will actually be in the bench.
The thing is that they are both on the Supreme Court, and the appeal now is being actually filed in the Supreme Court. The stay also which has been given is also by the Supreme Court.
But being short of judges to hear the appeal is not the Supreme Court's only problem. According to former Chief Executive of the Law Society of Kenya, Justice Njoki Ndung'u's actions amounted to gross misconduct and misbehaviour, and in fact he will Monday file a petition to have her removed from office. And these are his reasons.
She cannot purport to sit as a one-judge bench of the Supreme Court and give the orders that she purportedly gave. That's one issue, because if you read Article 165, it's very clear that in terms of Constitution, 5 bench. In terms of interlocutory or conservative orders that she gave, at least the practice there have been that there have been 2 judges.
The Chief Justice is responsible for the allocation of cases and setting up a bench to hear them. In his absence, the senior-most judge takes up the role, in this case, Justice Mohammed Ibrahim.
That application was actually drafted 2 days before the actual judgment that was given yesterday. And indeed, you could see within 30 minutes of the delivery of that judgment, there was an application filed for stamping before the Supreme Court. You can see that there was collusion. Either they were anticipating or they knew what was coming.
He has also questioned the length of the stay orders from the 27th of May to the 24th of June when the appeal is meant to be heard. The lawyer says this as a misuse of judicial authority, considering that injunctions last only 14 days.
What we are seeing then is that judicial officers now conducting themselves in a manner incompatible with their status, and they do not inspire confidence in that court. And they are opening the apex court for ridicule. Indeed, the legal profession are still baffled that judges who have reached 74 can go at great lengths, who have reached 70 can go at great lengths to insist on staying. And we are wondering, what do they want to do that they have not done for the period that they have been in the judiciary?
The decision by the Court of Appeal to retire the 2 judges had also raised questions on the future of the tribunal investigating bribery allegations against Justice Phillip Tunoi and divided opinion among lawyers.
In a way, I think is a reprieve for the Tunoi tribunal, because this means that we are not functus officio yet, and therefore we can continue with the tribunal's work. And I think that's also what the judge wants, because the judge wants this process to be concluded so that at the end of it, whichever way it goes, he doesn't have further anxiety.
The Commission on Administrative Justice had foreseen the crisis at hand. In an advisory opinion dated the 5th of January 2016, the Office of the Ombudsman wrote that since the matter was being handled by the courts, the decision of the Court of Appeal ought to have been accepted as final in the interest of justice, as a further appeal at the Supreme Court would be inappropriate and riddled with conflicting interests. Sheila Sendeo, NTV.